Welcome back to our channel, Just Immigration News. The legal consequences for undocumented immigrants leaving the United States with CBP Home. Please hit like and subscribe for an upcoming video. In the current and increasingly complex U.S. immigration environment, policy shifts are often presented as administrative improvements, yet their legal implications can be profound and lasting. One such shift is the replacement of the CBP One application with a new platform known as CBP Home, introduced under the Trump administration. While this system includes a feature that allows immigrants to report their voluntary departure from the United States, it does not shield individuals from the serious inadmissibility penalties mandated by Congress. Evolution of the CBP One and CBP Home applications. To understand the gravity of this change, it is important to examine how these tools evolved. The CBP One application was launched in 2020 and later expanded during the Biden administration to allow undocumented immigrants and asylum seekers to schedule appointments at designated ports of entry. Over time, it became the primary legal pathway for thousands seeking protection in the United States. Upon returning to the office, the Trump administration suspended this functionality almost immediately. Approximately 30,000 previously scheduled appointments were canceled, and the humanitarian national parole programs for Cubans, Haitians, Nicaraguans, and Venezuelans were terminated. By March 2025, the remaining functions of CBP One were fully transferred to the newly branded CBP Home application. This new platform introduced a feature enabling immigrants to notify authorities of their intent to leave the country voluntarily. The legal reality behind voluntary departure. What is critically misunderstood is that leaving the United States, regardless of how it is reported, does not prevent inadmissibility penalties. In fact, it is precisely the act of departure that activates them. Under the Immigration and Nationality Act, individuals who accrued unlawful presence in the United States become subject to reentry bars the moment they exit the country. A 3-year inadmissibility bar applies to those who remained without legal status for more than 180 days, but less than 1 year. A 10-year inadmissibility bar applies to those who remained without legal status for more than 1 year. These penalties do not take effect while an individual remains inside the United States. They are triggered only upon departure, whether forced, assisted, or voluntary. Consequences of self-deportation through CBP Home. By promoting CBP Home as a mechanism for self-deportation, the administration is effectively encouraging actions that will permanently alter an immigrant's legal future. Once an individual departs, using this system, many will find themselves barred from lawful reentry for years. Even if they have U.S. citizen family members, long-term employment history, or deep community ties. Waivers to these inadmissibility bars exist, but they are limited, highly discretionary, and extremely difficult to obtain. Lack of transparency and due process concerns. Perhaps the most troubling aspect of this policy is the lack of clear and comprehensive disclosure. Immigrants are not adequately informed that voluntary departure through CBP Home is an activity that involves legal barriers that may exclude them from the United States for a decade or longer. This absence of transparency raises serious concerns about fairness, informed consent, and due process. The practical effect of this policy is not merely facilitating departures, but ensuring prolonged exclusion once individuals leave. Understanding these consequences is not optional, it is essential. Decisions made today can determine an immigrant's legal future for years to come. That is all for today in this video. See you later in the next video. Till then, take care.